Welcome to the tutorial on business ethics. Today the chapter is ethical decision making, focusing on technology and privacy in the workplace. Nowadays, business world is a global issue and the technological revolution is largely responsible for this globalization fact. And due to technological revolution, there are opportunities as well as challenges. And the challenges raise ethical questions, particularly as this technology impacts employee and consumer privacy. However, this chapter will review some of the key ethical issues of technology and privacy, with a particular focus on privacy in the workplace. Definitions of privacy. There are two general and connected understandings of privacy. The first one is privacy as a right to be left alone within a personal zone of solitude. And the second one is privacy as the right to control information about oneself. That means privacy as a right to be left alone. And the second one is privacy as the right to control information. We must recognize that certain personal decisions and information are rightfully the exclusive domain of the individual. Ethical sources of privacy as a fundamental value. That means here we are going to learn about the sources of privacy. We can see the right to privacy is founded in the individual's fundamental and universal right to autonomy, in our right to make decisions about our personal existence without restriction. That means this is our universal right to restrict the intrusion to our personal existence. The right is restricted by a social contract in our culture that prevents us from infringing on someone else's right. That means in considering the social contract, we should not infringe on someone else's right. And the sources of privacy arises from the reciprocal obligation. Reciprocal obligation is a concept which implies that while an employee has an obligation to respect the goals and property of the employer has a reciprocal obligation to respect the rights of the employee as well, including the employee's right to privacy. That means in reciprocal obligation, both the employee and the employer has obligation to each other. A Bill of Rights for the workplace would therefore include both the right of the employee to privacy and confidentiality and the right of employers to privacy in terms of confidentiality of trade secrets and so on. That means in the consideration of reciprocal obligation, the rights in the workplace focuses on the rights of both parties, employee and the employers. The right of employee is the privacy and confidentiality, and the right of employers is the privacy in terms of confidentiality of trade secrets. In this slide we can see the sources of privacy. There are two sources of privacy. One is hypernorms, another one is moral free space. Hypernorms indicates the values that are fundamental across culture and theory, and moral free space is the environment where hypernorms or universal rules don't govern or apply. These two issues also should be considered as the source of privacy. We can see examples of hypernorms: freedom of speech, the right to personal freedom, the right to physical movement, and informed consent. However, the sources of privacy also arise from the hypernorms and moral free space. The ethical sources of privacy also come from the property rights. What is property? Property is an individual's life and all non-procreative derivatives. And derivatives include thoughts and ideas as well as personal information. And property rights indicate boundaries defining actions that individuals can take in relation to other individuals regarding their personal information. If one individual has a right to her or his personal information, someone else has a commensurate duty to observe that right. Legal sources of a right to privacy. Generally, we believe that each employee is a human with private thoughts, private communications, and a private life. But whenever a person as an employee thinks that he needs the job, in that case, he may need to give up his or her privacy, because in most of the cases, the business organizations are using lots of technologies and law has not yet caught up with the technology involved in employee privacy. That's why simply obeying the law may fall far short of responsible management practice. While the law might be clear with regard to tapping a worker's telephone, it is less clear in connection with monitoring a worker's email or text messages on a handheld device. That means, since there are lots of technologies using in the business organizations or in the workplace, law cannot cover all the issues because the categories of technologies are huge comparing to the law. 3 legal sources of privacy protection. Privacy can be legally protected in 3 ways: by the Constitution, by state statutes, statutes means law, state statutes means country law, and by the common law. Common law means the law arises from the decisions handed down by the courts. And in case of country law or state statutes, there is a terminology called intrusion into seclusion. Intrusion into seclusion occurs when someone intentionally intrudes on the private affairs of another, when the intrusion would be highly offensive to a reasonable person. As we begin to live more closely with technology and the intrusions it allows, we begin to accept more and more intrusions in our lives as reasonable. That means, since day by day we are using more technologies, in that case we are accepting more and more intrusions in our lives as a reasonable issues. Concept of a reasonable expectation of privacy. From the court decisions, it can be said that monitoring in the workplace can be done, but that monitoring depends on whether the worker had noticed that the monitoring might occur. That means monitoring in the workplace depends on the prior notice to the worker that there will be a monitoring. And this prior notice of monitoring issues is essential because the basis for finding an invasion of privacy is often the employee's legitimate and reasonable expectation of privacy. If an employee has actual notice, then there truly is no real expectation of privacy. That means monitoring can be done, but before monitoring, there should be a notice to the worker so that it doesn't break the reasonable expectation of privacy. Reasonable expectation of privacy is a situation where an individual is notified that information will be shared or space will not be private. There is likely no reasonable expectation of privacy. We can say that in the concept of reasonable expectation of privacy, the employer should provide prior notice to the worker about the monitoring issue. Linking the value of privacy to the ethical implications of technology. Since new technologies are coming every day, There may be implications of new technology on employee and employer expectations regarding the issues of using the time, the distinction between work use and personal use of technology, the protection of proprietary information, performance measurement, and privacy interest. Accessibility issues related to the digital device. That means, since there are new technologies are coming in the workplace, there may be implications in case of expectations of employee and employer regarding the issues of using the time. That means whether employee is utilizing the time, that cannot be measured, and it cannot be measured whether the employee is using the technology for the work purpose or the personal purpose. And there may be less protection regarding the proprietary information, and there may be implications for performance measurement as well as the privacy issues. That's why we can say that technology has opportunities as well as challenges in the workplace. Recent developments in connection with employee monitoring. Nowadays, the employers are using email monitoring as well as the internet use monitoring in the workplace. One survey found that 21% of employers monitor employee emails and internet use. On the other hand, 33% of employers block employees from accessing certain websites at work. However, nowadays we can see the use of social media, and the employers can use this social media and social networking site to monitor the activities of the employee. Email monitoring indicates the maintenance and the periodic or random review of email communications of employees for a variety of business purpose. On the other hand, the internet use of monitoring indicates the maintenance and periodic or random review of the use of internet by employees based on time spent or content accessed for a variety of business purpose. That means employee can be monitored by using the email monitoring system or internet use monitoring system as well as the social media and social networking monitoring system. Risk involved in a failure to understand the implications of technology and its use. I mean, as an employee, if we don't know the risk involved in failure to understand the technology, we may face problem, because when we don't completely understand the technology, in that case, it would be difficult for us to understand the ethical implications of our decisions, as well as we may not be able to protect our own information because we may not understand the impact on our autonomy, the control of our information, our reciprocal obligations, or even what might be best for our personal existence. That means if we don't know the implications of technology, there may be risk for the employees because he or she will not be able to understand the technology. That's why he will not be able to protect the information. Experts tell us that system is penetrable. I mean, the website system or internet system is penetrable by the administrator. Employers have been known to randomly read emails to ensure that the system is being used for business purposes. That is why we can say that as an employee, we must be aware about the technology, otherwise we will not understand the implications. That's why, as a result, we may not able to protect our information or privacy. As an employee, if we don't know the use of technology, we may face various types of risk. As per example, you cannot guarantee that your boss will not forward your disparaging remarks about a colleague directly to that colleague, because this can be done just by touching the key of a keyboard. We should also be aware that people could always send or show your letter to someone. As well as we can see, you may hit the delete button to delete a email, but it does not always delete that message from the server. It might be retrieved by your supervisor or have a negative impact in a lawsuit. That's why as an employee we should be familiar with the technology and the use of technology. Otherwise we may not be able to protect ourselves and we may be hampered by the people who do understand the technology. Additional ethical challenges posed by technology use. There are various ethical challenges due to technology use. As for example, we cannot guarantee that our email will not be accessed by others. Intentionally or unintentionally, other people can access your email, as well as by using the technology, your boss or your supervisor may check your background. In that case, he or she may uncover information of an extremely personal nature. There is one kind of limitations due to the technology. And another thing is that since we are using technology, we are connected with everyone. In that case, your boss or your supervisor is also connected with you. And for that reason, there may be problem, because suppose you are in the event of your sister's wedding. Since you are connected with your boss using the technology, your boss may expect that you should reply the email of your boss. That means since we are using technology, there are new expectations, and the more expectations, more conflicts. Another challenge is that facelessness. Facelessness means whenever we meet someone face to face, we cannot react in a bad way. But whenever we think that the person is living in a remote area and you are not known to that person, in that case, since you are not afraid of facing the people, you can say anything. That is another challenge. Reasons for which employers choose to monitor employees' work. There are various reasons for which the employers can monitor the employees. Some of the examples are to ensure compliance with affirmative action requirements, to administer workplace benefits, to ensure effective and productive performance by preventing the loss of productivity to inappropriate technology use, to protect employers' others' resources, to protect proprietary information and to guard against theft, to protect their investment in equipment and bandwidth, to protect against legal liability. So these are the some reasons for which an employer can monitor the activities of the employees in the workplace. Ethics of monitoring regarding the issues of drug testing of employees. Drug testing is a way to monitor the employees, and in that case the ethical issues arises for the employer and the employees. Employer has a strong argument in favor of drug or other substance testing based on the law, because whenever any crime is committed by the employee, in that case the employer is often responsible. That's why employer is interested to monitor the employee by using the drug test. On the other hand, employees may argue that their drug usage is relevant only if it impacts their job performance. I mean, if the use of drug impact on the job performance, in that case the employees may be agreed to go through the drug test. These are the two contexts of ethical issues in drug testing for the purpose of monitoring employees. We can see some impacts of using drug by the employees, but as an employer, he or she should be cautious, because there may be incorrect presumption in connection with the drug testing, because These are some impact which arises from the use of drug, but drug use is not only the source of such impact or such behavior. However, we can see the behaviors in the perspective of job performance due to drug use are inconsistent work quality, poor concentration and lack of focus, lowered productivity or erratic work patterns, increased absenteeism or on the job presenteeism, unexplained disappearances from the job site, carelessness, mistakes or errors in judgment, needless risk taking, disregard for safety for self and others, on the job and off the job accidents, extended lunch periods and early departures. On the other hand, due to drug use, there are maybe some workplace behavior such as frequent financial problems, avoidance of friends and colleagues, blaming of others for own problems and shortcomings, complaints about problems at home, deterioration in personal appearance or personal hygiene, complaints, excuses, and time off for vaguely defined illness or family problems. These are the some behaviors which may arise from the drug use, but an employer should be cautious or careful regarding this symptom, because not only the drug use can cause that type of behaviors or performance, there may be other issues. Ethics of monitoring as it applies to polygraphs, genetic testing and other forms of surveillance. Since we are aware that due to technological development, the employers are using various methods to monitor the activities of employees in the workplace. As for example, the employers are using polygraphs and drug testing, physical and electronic surveillance, third-party background checks, psychological testing. However, whatever be the method used by the employers in monitoring the activities of employees in the workplace, the ethical issues should be maintained by the employers. As for example, we can say by the genetic testing, the employer can get information about the family members of the employees. In that case, businesses can gain wealth due to the collection of information about the potential employees and the customers. That's why there is a ethical issue. That type of ethical issues should be dealt in a careful way, because the employees will be impacted by the use of such technologies. Why monitoring might also pose some cost for the employer and for the employee. This question is dealing with the problems or limitations arises from the monitoring issues. There are limitations or problems arises from the monitoring the employees. The first problem is that monitoring may create a suspicious and hostile workplace. By reducing the level of worker autonomy and respect, as well as workers' right to control their environment, the employer has neglected to consider the key stakeholder critical to business success in many ways, the worker. Due to monitoring issues, there may be suspicious and hostile workplace. In that case, the worker may think that they are being neglected. And the second problem or second limitations arises from the monitoring the employees is that monitoring may arguably constrain effective performance, since it can cause increased stress and pressure, negatively impacting performance and having the potential to cause physical disorders such as carpal tunnel syndrome. And whenever there is a stress, the employees may be unhappy and disgruntled, in that case the employees may seek alternative employment, and as a result there will be a high cost for the organization or the employers, because employee turnover is a great problem which increases the cost as well as it creates negative impacts on the employees. And the third problem arises from the monitoring the employees is that employees claim that monitoring is an inherent invasion of privacy that violates their fundamental human right to privacy. That means the employees may think that due to monitoring there may be violation of privacy. So these are the limitations or problems arises from the monitoring of the employees. Elements of a monitoring program that might balance the interest of the employee and the employer. That means what type of issues should be maintained to make a balance between the interest of the employee and the employer regarding the monitoring issues. The employer can make a balance in case of monitoring by respecting individual dignity as well as holding individuals accountable for their particular roles in the organization. That means workplace monitoring should be done by balancing two issues. The first issue is the employers should respect individual dignity as well as the employers should be concerned to hold accountable for the roles of the employees to the organization. To make balance between the interest of the employee and the employer should maintain integrity. In that case, he or she can consider the following parameters such as no monitoring in the private areas, as for example restrooms, monitoring limited to within the workplace. Employees should have access to information gathered through monitoring. No secret monitoring, advance notice required. Monitoring should only result in attaining some business interest. Employer may collect only job related information. Agreement regarding disclosures of information gained through monitoring. Prohibition of discrimination by employers based on off-work activities. These are the issues which should be maintained by the employer as an integrity to make a balance of the interest of the employee and the employer. The interest of an employer in regulating an employee's activities outside of work. Nowadays, some of the employers are interested to monitor the activities of employees outside of work. In that case, considering the ethical issues, the employer should not monitor 4 categories of off-duty activity such as legal recreational activities, consumption of legal products, political activities, and membership in a union. That means these are the some off-duty activities which can be done by the employees, and whenever the employer is monitoring the activities of employees, he should not create any prohibition regarding these issues, because these are the some issues which should not be prohibited by the employer. If there is a prohibition in such legal activities, in that case there may be conflict between the employers and employee. That's why before doing off-duty monitoring, the employers should be concerned about the employees' privacy. That's why we can say that whenever the employer is monitoring the off-duty activities, he should not create any prohibition regarding the 4 aspects such as legal recreational activities, consumption of legal products, political activities, membership in a union. In summary, we can say that the employers can monitor the activities of employees in the workplace, but in that case ethical issues should be maintained, otherwise there may be conflict, and due to the conflict there will be employee turnover In that case, the organization or the employer may face difficulties. Thank you.